All right, everyone. Thank you for waiting. We wanted to give everyone just a few minutes to get settled for our presentation today. My name is Brian Rowe. I'm Director of Experiential Education in the AU Career Center. And this presentation is around the fundamentals of applying for and obtaining a security clearance. We are joined today by an expert in this field. Peter Jeffrey from the Jeffrey Law Group is an expert and a specialist in employment law. And I'm going to turn it over to him so he can get started right away. So Peter, welcome and thank you.
Thank you for that introduction. As was described today, we're going to be talking about the fundamentals of applying for and obtaining a security clearance. But because I'm a lawyer, despite the lack of suit and tie in our, I guess, new endemic world, I just want to put out a brief disclaimer that the information that I'm providing is of a general nature and shouldn't be considered specific legal advice in any situation. And so basically, don't rely upon this at home. If you have a specific issue, you should move forward with contacting an attorney directly. So why are you here today? Or I guess, what are the learning outcomes or objectives that we're looking for? Well, if you're planning to apply for a federal government internship or job, chances are that you may be required to obtain a security clearance or at least a public trust position. If you understand what is required of you now, the process for applying for and obtaining a clearance may be easier in the future. And hopefully this information will help you kind of strategically plan if and when you would apply for a government position and keep you from some heartache down the road. So key concepts in security clearance adjudication and obtaining a security clearance. The first is the federal executive branch controls who receives and retains a security clearance. What that means is that it is not reviewable. Those decisions by the federal executive branch are not reviewable by the judiciary. There's no third party review of the government's decision as to who gets to maintain or be granted a security clearance. Fundamental under that, the Supreme Court decision that established that is that a security clearance is a privilege, not a right. And you'll see, in order to be granted that privilege, you'll have to disclose quite a bit of personal information about yourself. And last, and I guess most importantly, all doubts concerning a person having a security clearance will be resolved in favor of the national security. And basically what that means is if there is a security concern, and I'll address what those security concerns may be, the default answer is no, not to grant the person a security clearance. So what's the process overview in terms of the security clearance procedure, process, and experience? Well, the first is a government activity. So an employer, be it the Department of State, USAID, the Department of Justice, sponsors you for a personal security clearance. What that means is that you've been either hired by that government activity, by that department or agency, or you've at least been given a tentative offer that you've accepted, conditioned upon your suitability and ability to obtain a security clearance. Once that sponsorship happens, you'll go through you'll have to apply by submitting a questionnaire. Thereafter, there's an investigation that can vary in scope. The next is an adjudication, and that's just a fancy way of saying that the sponsoring agency will take the completed investigation, determine whether or not there's any security concerns, and then make a decision as to whether or not to grant you a clearance. I think going back to kind of the process overview, though, you must be sponsored for a personal security clearance. No one can go ahead and ask to apply for a security clearance. There has to be a need and a sponsorship for it. So unfortunately, if you see jobs that say a security clearance is required to apply, there's no way of you obtaining one unless you have been granted a clearance in the past. So first and foremost, I would suggest to everyone, even if you're going to sign off at this point, if you thought you were going to ever apply to the federal government, you should take a look at the guide to the standard form SF-86. That is a questionnaire that is used primarily for security clearances, and determine whether any of your responses to those proposed questions may give you an issue or concern that would preclude you from being granted a clearance. So first, you will fill out the questionnaire once you've been given that tentative offer and sponsored. There's several different questionnaires. The ones for national security positions are called an SF-86. Almost everything now is handled through EQUIP, the electronic questionnaires for investigations processing. And they'll ask you a series of questions, basically about your entire life, your education, where you lived, your foreign contacts, your familial contacts, who's lived with you, your past residences, your education, the full scope of your employment history, as well as questions that relate to lifestyle and conduct, your alcohol use, criminal conduct, if any kind of disciplinary issues at school, drug use, past employment in terms of firings or any other type of discipline. And they'll also ask you questions about debt and mental health care. After you've submitted the EQUIP or this application for a security clearance, typically an agency, in most cases now, it's the Defense Counterintelligence and Security Agency, will perform an investigation of you. First, based upon your answers to that questionnaire. And in terms of its background investigation, typically they'll search law enforcement entities, so do a national criminal information check. They'll contact past employers, your educational institutions, and request past records about you, including any transcripts. They'll pull a credit report or various credit reports and any other record repositories that relate to the questions on your questionnaire. Now, in order to seek the privilege of a security clearance, you must grant the government, you'll waive your privacy in those regards. So you will submit a waiver so that in most cases, the DSCA will have the ability to get those records from your past employer, from your educational institution. They'll have the ability to do a credit check as well as contact law enforcement entities and past employers. Also, they may interview your friends, co-workers, landlords, family, and neighbors to verify where you lived, worked, or went to school. And last, you may be interviewed yourself to expand or clarify the information you provided on your investigative questionnaire. For anyone who would be applying for a clearance that's at the top secret level or any special access above that, you can expect that full scope single background investigation. Typically, if you're applying for a public trust position, the investigation is more limited to kind of a records check in terms of national criminal databases, courts, employers, and so forth. Upon the completion of that investigation, your sponsoring agency, be it the Department of State, USAID, will begin what's called the adjudicative process. And that they'll look at a set of 13 adjudicative guidelines, the lucky number 13, through a whole person concept to determine whether or not you should be granted access to classified information. And in terms of the investigation, they will look at all information, both favorable and unfavorable to you, making their determination. The purpose basically of this process and of the 13 adjudicative guidelines that will lead their decision is to determine whether or not you're trustworthy, reliable, and have allegiance to the United States. So how do you determine your trustworthiness, reliability, and being an overall good security risk? Well, there's 3 favored qualities or factors that the government is looking at for you to demonstrate in terms of your questionnaire and the way you've lived your life. 1, a strong sense of social responsibility, self-control, and the ability to maintain personal or job commitments over time. So here are the 13 adjudicative guidelines that the executive branch of the federal government will weigh your completed investigation against to see whether or not you are a good security risk to have access to classified information. And what I'll do now is there's some that I think are more applicable than others to recent graduate students or recent college graduates as they look for applying for a job as compared to others. So we'll look at several of the adjudicative guidelines and drill more into those. The ones that we'll really be looking at are foreign influence and preference, personal conduct, financial considerations, alcohol and drug involvement, and psychological conditions. Now, in the adjudicative process, when they're looking at all of these 13 adjudicative guidelines, there's several factors that they'll look at in determining whether or not you're a security risk. Obviously, they'll look at the seriousness of the conduct, the circumstances surrounding the conduct and your participation, frequency and recency, and that'll be a theme that'll come up throughout, especially when we're talking about potentially mitigating a concern, your age and maturity at the time, what steps have you taken that show rehabilitation or permanent behavioral changes, and the likelihood of continuation or recurrence. And some of the mitigating factors overall that are looked at under the 13 adjudicative guidelines is whether or not you voluntarily reported the information. So were you truthful and complete when you responded to questions in the application? And did you seek assistance or follow professional guidance when the underlying conduct that gave rise to the security concern occurred? And more importantly, or equally as important, have you just demonstrated positive changes in your behavior and employment since the conduct that gave rise to the security concern occurred? So let's look a little bit deeper into some of the adjudicative guidelines that I think are most applicable to first-time applicants for security clearance, especially those recently out of college or graduate school. The first is alcohol consumption. There, briefly described, the security concern is whether or not your consuming alcohol has ever related into any kind of work-related or criminal conduct. It doesn't have to necessarily rise to that level to still be a security concern, but they'll look to see whether or not there's been a pattern of alcohol abuse or alcohol-related offenses. The mitigating factor, though, in regards to that concern is time, counseling, and rehabilitation. And you will see a constant theme with almost every adjudicative guideline. Time usually mitigates most concerns. So time from the conduct from basically to the time of your application. So here's a sample of the questions that will show up on the EQIP or the SF-86 that you have to truthfully and answer in regards to your alcohol usage. As you can see, the first questions relatively broad in asking whether or not alcohol has ever had a negative impact on your work performance. It's not just in terms of intervention by law enforcement, public safety, but they'll ask questions such as, have you ever called in sick because you were hungover after a night of drinking? Have you ever showed up to work drunk? I mean, those are questions that will give rise to a security concern and that they'll look at. Another concern, security concern under the Adjudicative Guidelines, is drug involvement. There, they're looking for not only drug abuse, but any possession or use of illegal drugs. Now, the mitigating factors, once again, time, distance and time from the conduct to the point of you applying, but also your disassociation from drug-using contacts, change in environment, and any successful completion of counseling. But, and I think it's important to note is that even though in many states now recreational possession and use of marijuana has been legalized, such as in DC, it's still a controlled substance subject to federal criminal prosecution. And it's flatly prohibited for all military members. So even though it's been legalized in many states, including the District of Columbia, it is still a security concern if you use marijuana, even just once. That also includes if you used marijuana outside of the United States where it otherwise would be legal, such as in Amsterdam. And it even applies to medicinal use of marijuana. And I'd note that as a matter of state law, at least 5 states that allow the use of medicinal marijuana have not extended that protection to people, disabled individuals who use it as a means of reasonable accommodation. It won't prevent their termination from employment. And once again, here's a sampling of the questions that'll be asked on the EQIP or the SF-86 in regards to drug use. I'll point out that the default is usually in the last 7 years, but typically when you apply for a first clearance, the government can go back as far as 10 years on the questionnaire, and in fact, any use, and they can ask questions beyond that period of time. But the 7 years gives you an indication as to the passage of time that normally is necessary for a security concern not to arise given that conduct. Now, this gets a little bit trickier and in some ways somewhat fundamentally unfair in terms of foreign contacts. And remember that a security clearance is a privilege, not a right. And I say that it's sometimes fundamentally unfair, the foreign contact security concern is because unlike alcohol and drug use, this is a behavior or conduct that you otherwise may not even have control of. So the security concerns could be possession of a foreign passport because you have dual citizenship, military service for a foreign country, or any action to acquire foreign citizenship, or any affiliation or affection with a foreign national. I could include parents, grandparents. If you've immigrated, it can include your significant other. Now, mitigating factors typically are if it's dual citizenship, if it's based on birth or parent citizenship, and a willingness to renounce foreign citizenship. But the concern is twofold in terms of foreign contacts. One is foreign influence. Is there the ability of a foreign country to manipulate you? And here it would be, some of it depends upon the country at issue. But if you have relatives that you have close familial contacts with, or a significant other with relatives in a foreign country, particularly ones that may be hostile to the United States, they could see this as you would have a foreign influence and you could be excluded from having a security clearance, because the concern would be that the foreign country could manipulate you or blackmail you based upon what they could do to your close personal contact in that country. The flip side of that is whether or not you have a foreign preference. Is there concern that you would favor another country over the United States if asked to take sides? So if you were a dual citizen. And here again, a sampling of the questions that would be on the eQuip in regards to foreign contacts. Now, I'll point out that increasingly virtual contact is being discussed and considered in adjudication. And while there's no cases that we've seen where a clearance has been denied solely based upon virtual contact, it is routinely noted. So your contact, your virtual contact with family members, academic colleagues, friends via Facebook, Zoom, Twitter, Instagram, those friends you've made perhaps if you went backpacking a month through Europe, those will all need to be disclosed and they will be looked at. Now, I'll also point out, and in terms of security clearances, a basic tenet, a basic qualification is you must be a United States citizen. And typically, having dual citizenship alone won't disqualify you, but you typically have to demonstrate that your allegiance is primarily to the United States, which would include either being willing to revoke your dual citizenship, giving up your passport. And primarily what they're going to look to in terms of dual citizenship is, have you ever exercised any of the rights and benefits granted you given the citizenship of another nation? So typically, if you've worked for that foreign government or for the other government, if you've voted in their elections, if you've used that passport to travel, those could all be security concerns that could lead to your denial of a security clearance. Another adjudicative guideline is financial considerations. And this is a very common one throughout, not just for students, but also in regards to people who've maintained a clearance for quite a long time. And there the concern is that your inability or unwillingness to satisfy debts or irresponsible spending, poor credit history, question your reliability and trustworthiness. Typically, though, the mitigating factors in this regard is the time since that debt. Did you satisfy the debt? Did you operate as a reasonable person would in terms of the debt? And then what were the conditions that gave rise to the debt? Were they beyond your control? Such as losing your business during a pandemic or a catastrophic health issue that led to the indebtedness and the inability to work. Those will all be considerations. And once again, just a sampling of what type of questions will be asked on the eQuip. Typically, they're going to ask if you've had not only defaulted or debts turned over to a collection agency, but whether or not you have any accounts receivable that you owe on that are more than 90 days old. Another concern is the use of IT systems. I point this out, illegal or unauthorized use of an IT system shows an inability or unwillingness to follow rules, which would give rise to security concern. I would say that one of the concerns would be sharing your roommate's Netflix account after you move out of your combined apartment. That would be considered misuse of an IT system. So mitigating factors are time, misuse was minor, or the conduct was unintentional. Once again, here's a question that you'll find on the eQuip, going directly to your use of IT systems. Now, I did mention, sharing the Hulu or Netflix or whatever streaming account that your roommate may have, especially once you've moved on, could give rise to that. But it also, the security clearance adjudicators have pointed out that accessing another person's account, be it Facebook or Gmail account, even though not necessarily unlawful, but snooping on them would raise this security concern. Next, I'd go and talk about a little bit about the adjudicative guideline regarding psychological conditions. The security concern there is that mental health influences how a person perceives the world, makes decisions, and manages stress. But primarily what an adjudicator is looking at is whether or not the mental health issue leads the person to be emotionally unstable, irresponsible, dysfunctional, violent, paranoid. And on top of that, whether or not there's been a failure to follow treatment. There is an executive order that clearly states that seeking mental health counseling in and of itself is not a negative factor, and it cannot be used in and of itself as a negative determination or the reason for a negative determination to be granted to security clearance. Nevertheless, you have to disclose any psychological conditions or any mental health counseling you've had. There are some conditions that I won't necessarily say immediately disqualify you from being granted a clearance, but more likely than not, paranoid, schizophrenia, bipolar, the more severe the mental health issue, the less likely you will be able to obtain a security clearance, but not necessarily, because it's based on this whole person concept, and we'll look at the overall treatment, because the mitigating factors typically will look to see whether or not the condition is being controlled with treatment and you're complying with the treatment plan, whether or not you voluntarily entered counseling or treatment and the condition's amenable to treatment, and or moreover, whether or not a mental health professional has said that your condition is under control or in remission. So seeking mental health counseling in and of itself doesn't disqualify you. It's something you must disclose, just like your past employment, as well as your past academics. But it could give rise to a security concern. The more severe the mental health issue, the less likely you'll be found eligible for a security clearance if, in fact, that mental health condition would lead to you to be irresponsible or emotionally unstable, violent, or paranoid. But there are mitigating factors in that. And as I said, looking at the DSM-5, a lot of it will depend upon what your diagnosis and prognosis is. Last kind of a catch-all is personal conduct. Personal conduct, most importantly, is whether or not you lie or lack candor, both in the past as well as in this application. Really, what the government is looking at is whether or not you have any conduct that involves questionable judgment, a lack of candor, dishonesty, or unwillingness to comply with rules. And I can't say this enough. Even though I've listed some mitigating factors, if you have lied or lacked candor on that questionnaire or during the investigation, or even on your initial employment, your resume, your CV for employment, unlike most of the other adjudicative guidelines where time will demonstrate rehabilitation, there is almost zero way to mitigate lying or a lack of candor being found as a security concern if the government can sustain that. And then ultimately, hopefully you don't get to this point and you're granted your security clearance, but if not, if there's a denial or later a revocation of a security clearance that's been granted, there are minimum due process rights that are afforded internally through the executive branch through administrative hearing. You're entitled to a comprehensive and detailed written explanation as to why your clearance is being denied or revoked, any of the evidence that's relied upon to support that denial or revocation. You have the right to review. You can be represented by counsel or other representative and reply in writing and request a review of that determination. And at some point, the ability to personally appear and present documents, materials, and other information to have that overturned before an internal adjudicative authority. I do have kind of some case study examples to go through regarding the adjudicative factors I've discussed, but I do see that there's some question and answers, and I don't know, Brian, if this is a good time to take some questions before I jump into the case studies.
Yeah, thank you, Peter. That's good. We do have two questions that have popped up. They both look like they deal with international contacts and relationships, international relationships. One person has asked that, well, we said they were a PMF finalist. So this is the Presidential Management Fellow. First of all, congratulations on being a finalist for that. And this person is a dual citizen, US and Brazil. And they're asking if you have advice on what they can do to show that their foreign contacts will not be a security concern regarding the foreign preference.
All right. So part of it will depend upon what level of clearance the PMF finalist would need, and ultimately the position they were placed in. And I know there are some that it would just be level of public trust and not require a security clearance. And I would say that if you're a dual citizen, conservatively, that's where you should look for your placement. The real concern in regards to the security clearance would be if you're a dual citizen, is there anything in your background or with your familial contacts that would question your foreign preference? Your foreign preference has to demonstrate that it would be the United States. One, are you willing to give up your dual citizenship and give up your Brazilian citizenship? The other issue too would be, and something you might not necessarily be able to control, is whether or not any of your family members work for the current Brazilian government. And if that's the case, especially if it's a parent or sibling, even uncles or aunts, that may be enough of a reason to disqualify you. They also will look at the country of origin, and that changes over time of what our relationships may be with various countries. But I can tell you that, and it's later in my case study, that there was a 60-year-old grandmother who'd worked for the Department of the Navy, held a clearance for 25 years, and then had that clearance revoked because she had dual citizenship with both the US and Israel, and 3 of her brothers worked for the Israeli government. And even though that she had held a clearance and been successful and had ties to the United States, that was enough of a reason to deny the clearance. Because remember, the fundamental or the default answer is no, not to grant the clearance if there's any security concern. And that's why I said there's somewhat a fundamental unfairness with that. Even if you renounced your Brazilian citizenship, depending upon your family contacts and what they're doing in Brazil and their relationship to the government, that could disqualify you in and of itself.
Okay. The next question is on a similar topic. For affection, attachment with foreign nationals, what is the level, how granular should we be? So do you need to detail every date you ever went on with someone while abroad, for instance? And many of our students either are studying abroad, as AU students, or graduate students may have studied abroad in their undergraduate programs. If you went on a date with someone in Paris, right, when you were there 2 years ago, do you need to sort of say, well, I went on a date with this person? Or how granular do you need to be?
Not necessarily. I mean, the question is, do you still have contact with that person? Is that person your Facebook friend? Do they follow you on Instagram or Twitter? Then you may have to. If you have had no contact beyond the period of time, that one date, then more than likely you do not. I have to say that we normally counsel our clients or prospective clients that default to disclosure, because it won't, as I said, the foreign contact, especially if it's that tenuous, could be mitigated if there's a concern. The one concern you can never mitigate, at least in the short term, is a lack of candor. And so if you get to the investigation and that information is developed because they speak to someone else who is a fellow grad student on that same trip, and they mention that relationship, then suddenly you have to explain why you didn't disclose it. One of the other ways of kind of getting around that is you will always have a security officer point of contact assigned who you'll be submitting the equip through. You can always ask questions of them as to whether or not you need to disclose something, but make sure that you're asking that in writing, at least via email, so you have a record, so that if you won't have an issue, or you'll have a response to a lack of candor that I say gives you somewhat of a safe harbor, because you can demonstrate that, oh, I wasn't sure if I needed to disclose this, but then I asked the security professional. And that's not necessarily, don't ask outside counsel. I mean, you want to ask the government. You wouldn't ask me, you'd ask the government.
Right. Okay. So you tend to overdo it when you're sharing these contacts, even if you think, well, it was one date 2 years ago, but we follow each other on Instagram, I'm going to list that. Right.
It won't be a concern, but the concern would be if you failed to list it. And it's kind of the absence. It's the alternative, or contrary to, like, if you were subject to a criminal investigation. I have to say, to some extent, when you're investigated for a security clearance, it feels like a criminal investigation in part. I mean, they're trying to see if there's any wrongdoing. But there, in that situation, you'd only answer the questions that are asked of you. Here, you want to be as candid as possible because you're seeking a privilege. You're not exercising a right.
Right. We have another question in the similar vein here. We have a question about, should we list every single foreign contact, including children, that we have ever been in contact with? Also, can I use my foreign citizenship to, they've written bypass visa process in EU. I think they might mean, when you arrive at an EU destination and there's the EU passport holder line and it's fast, right? And then there's everybody else and you have to wait, right? So if they've used their EU passport to, to kind of fast track through, is that
can be very problematic.
Okay.
So I say that because one of the case studies that I pulled, and when I'm talking about these case studies, so in terms of government employees, they do not publish the decisions as to these adjudicative hearings that they hold, whether or not to grant someone a clearance after a review determination. But they do that for federal contractors. It's a little bit more transparent. So the case studies I'm pulling are for contractors, federal contractors who have been denied or had a security clearance revoked. And in this instance, there was a Canadian, dual citizen who frequently used their Canadian passport for travel, and coupled with that, they stated that they would not give up their Canadian passport. as a condition of getting a security clearance, and therefore it was denied. But I mean, if of any country that we have, the United States has close ties with, and very little acrimony, is Canada. So I mean, so I would caution that by using the EU passport to bypass the security lines, you are somewhat demonstrating at least a foreign preference, because you are using a right or privilege or benefit of your other citizenship. So that could be concerning. As far as all the contacts list, you don't have to, you list those contacts that are close to you. That being said, how close is close? I've been a federal employee myself in the past and held security clearances. When I got married, my wife's mother, although a US citizen, naturalized from France. My wife had several cousins and aunts who are French citizens living in France, who I had not even met at the time. And when I had to update my security clearance, I had to list them because they were close affinity, at least to my spouse.
Right. Two more questions, and then we'll get going back with the presentation. How long do clearance investigations take? And is there any way to speed up the process? And my question sort of relates to this. Is there information that a person can gather to help, speed it along, right? So that when they're submitting things, they can go right away. What would you recommend they gather beforehand?
All right, so I'll break that apart a bit. I think anyone who is considering applying for a federal government job, be it an internship or full-time employment, should, even before you submit your application, or at least before you accept a tentative offer, you review all the questions that are on the SF-86, draft your responses to them, as well as what's called an optional form 306, which is a declaration for federal employment, and determine whether or not any of those answers you think would hit upon a concern in the adjudicative guidelines. So basically do a self-audit, whether or not, something may give rise to a security concern. The sooner you can submit your EQIP, the sooner the investigation begins. There's nothing, though, that you can do to speed an investigation along. It's completely up to both the employing sponsoring agency as well as the resources of the government and what priority your position's in. I will caution people, and this is a terrible position for people to be in, and it happens far too frequently. If you apply for an internship, that requires a security clearance. Typically, the government can grant what's called an interim clearance, usually at the secret or maybe even top secret level, if nothing kind of pops on the National Criminal Investigative Background Check or your initial responses to the SF-86. Ultimately, even if something would pop on that, you could get you might be able to get a clearance granted. But if you're denied an interim clearance, there's no appeal rights of that. And more likely than not, your internship will either, the period of time that was available for it will have passed, or the employing agency, from their own opportunity standpoint, will rescind the internship offer. And then when you apply for the federal government job again, you'll have to list that you've had a clearance denied, even if you've never had the ability previously to appeal or request reconsideration of that. So when you have to be very strategic if you're going to apply for an internship, if you have things that will immediately qualify for further investigation and wouldn't lead to the granting of an interim clearance, such as dual citizenship, foreign contacts, close foreign contacts, if you have something in terms of criminal record, or even bad debt, or if you're in a credit dispute that ultimately will be found in your favor, that will slow up or impact your ability to get an interim clearance, which overall will impact your ability for future federal employment because you lost out on an internship.
And this last question, if you're denied for any reason, how long until you can reapply?
There's typically a 1-year ban on being reapplied. The difficulty is going to be, you're going to always have to disclose that. And like I said, you're not applying yourself for a security clearance. You must be sponsored. So that means you either are in a position already employed by the government, or you've been given a tentative offer of employment. So typically those who are reapplying are either people who've been denied, but then otherwise hired by the federal government in another position that didn't require clearance, and then a period of time passes and they can reapply, or they have such a significant skill set that a federal contractor is willing to take the risk on sponsoring them a second time around.
Peter, thank you.
And as I said,
let's resume.
I was going to say, in default, as I said, in most of the adjudicative factors, time is a huge mitigating factor in between the conduct and the reapplication, but 1 year usually isn't enough time.
Okay.
We typically tell people who've been denied a clearance or had a clearance revoked that on average you need to wait a good 3 to 5 years before anyone would take you seriously. And we somewhat glibly, but if you follow the case law, find a God, find a family, or be promoted at work is what's going to give you mitigation. The adjudicative judges, the administrative judges, at least hearing the security clearance contractor decisions, equate promotions at job, higher education, marriage and children, or involvement in any kind of community activity, be it a church, synagogue, temple, or local government, to be signs of rehabilitation moving past the conduct.
Okay, thank you. Please proceed with the case studies.
All right, so just to give you a bit of flavor of what are the practical kind of facts that led to the denial or grant of clearance when there was a security concern. Here we have an applicant who disclosed their marijuana usage, primarily social during college, but only a couple of times post-college. And despite that full disclosure and honesty in their application, the clearance was denied. Once again, even another clearance denial, once again for marijuana usage. This, though, I'll point out, was more egregious because they worked for a government contractor and held a clearance. And while they were holding a clearance and working for a government contractor, their clearance was denied. This goes beyond the drug involvement security concern. This will also go to personal conduct and criminal conduct, because it is illegal to use any type of controlled substance when you hold a security clearance. So, warning to those of you that don't apply for a federal internship, be granted a clearance, and then eat an edible. Here, however, contrast that to someone who had a clearance granted. They voluntarily disclosed their illegal use of marijuana. They were candid and forthcoming, and they could show that they abstained for 14 months, had an outstanding academic and job performance record, and signed in a statement of intent not to use any illegal drug in the future. There, the clearance was granted. As you can see from the first case we talked about, I don't see much difference in terms of the facts of this case. So, when it's that recent, it could go either way. Here's a case about alcohol abuse. Here a clearance was granted, even though this person had a DUI, at least 2 DUIs, and they had a pattern, although the DUIs were 11 years apart, because the clearance was granted because the person testified to never drink again after consuming alcohol and went through a period of rehabilitation. And here we go to, I talked about this earlier in answer to one of the questions. Here, a dual citizen of the US and Canada, because he was unwilling to renounce his Canadian citizenship and continue to use that passport, the clearance was denied. And I discussed this question as well, or this case as well, in answer to a previous question. Here's the 61-year-old mother, 29-year career, held a clearance 25 years. But because she worked formally for the Israeli government and had 5 siblings living in Israel, 3 who worked for the Israeli government, she was denied a clearance because of her foreign preference and foreign allegiance was questioned. Although contrast this, here we have a dual citizen who naturalized to the United States, applied for citizenship, became a citizen in 2006, intended to spend the rest of the life in the US, never worked nor of her family's worked for the Taiwanese government, and had only been to visit Taiwan 4 times. And at the time of hearing, and this, point this out, her mother and all of her siblings had acquired permanent resident status. This person was granted clearance. Moving on to kind of case studies on debt. Here, an applicant defaulted on $70,000 in student loan debt. But the reasons, the judge found the reasons were beyond his control. And as you can see from the fact pattern, he attempted to repay his debt in a timely manner, act reasonably, sought credit, financial counseling, had a financial plan in place, and was saving, didn't use credit cards. I don't know how you would be able to do that anymore, but their clearance was granted. Contrast that to someone, single, 29-year-old woman, no kids, never married. She had 20+ debts worth more than $20,000. She quickly paid down more than half the debt in weeks before her hearing, but her clearance was denied. Why? Because the manner in which she incurred the debt and then in fact demonstrated that she could pay off that debt but didn't bother, didn't show that she was reliable or trustworthy. And so, really it's not the amount of debt that comes into question, it's more the circumstances and how you acted in terms of paying down that debt. And I'll leave you with, as far as case studies go, it may not just be what you did, but also who you know. Here, this case was the applicant was denied a security clearance because his wife, not he, but his wife maintained 2 hardcore pornographic websites, which included photographs of her. And because neither his family nor his employer were aware of those websites, the government found that the applicant was vulnerable to exploitation or coercion, and the clearance was denied. So kind of 2 closing principles that I leave you with. One, there's no right to a security clearance, and the default answer is always no, not to grant the clearance if there's a security concern. And more importantly, never lie in your application. Candor goes a long way. Most of the other conduct issues, concerns can be mitigated, particularly over time, but a lack of candor or making a false statement on a government application can almost never be mitigated.
All right, we have time for maybe one question. If anyone has one question, the first one that pops up. If not, Jeffrey, Peter, thank you so much for sharing your contact information with the students. And we really appreciate the information you gave. This is obviously a complex and nuanced subject. So we really appreciate your information. And we have one question. Does everyone go to a hearing, or is that when there is a concern?
So the only time you can elect to go to, may elect to go to a hearing if there is a denial or revocation, a final decision denying or revoking your clearance. Most clearances, even if there is a security concern, it is mitigated by the agency or considered mitigation by the agency by the investigative packet they receive. And you'll never know if there was a concern or not. You'll just be granted a clearance. It's only when a clearance is denied or revoked that then you may have the right to a hearing. I can tell you from a practical standpoint, everyone has a right to go to a hearing, but because the default response is no, a lot of times hearings aren't worth the time, effort, and expense, even if you're going on your own. The government only needs to prove that the underlying concern occurred by substantial evidence, pretty low threshold. The reasonable person could have found that the conduct occurred. And then it all falls on the applicant to mitigate that concern, to convince the hearing officer that they're not going to be a risk to national security.
Okay. All right. Well, we're at 1:02, so I believe we're at the end. Again, Peter, thank you so much for this time you've spent with us. And students, thank you for attending this presentation.
Thank you.
Goodbye. Bye-bye.